Family law cases involving kids are often challenging and even contentious. In high-conflict situations, the best option may be to ask the court to appoint an outside expert to address these issues. In the next few minutes, I'll explain how these experts can protect your child's best interests and help your case. So typically, you'll see a parenting expert in a situation where there's questions about things like substance abuse or who's going to exercise parenting time on a given date and time. One of the things that the court applies when deciding what's best for the children is trying to figure out if an expert is necessary. So typically you'll see that in a situation where either one of the parents wants that, or if the court sua sponte, meeting on their own, decides to appoint such an expert. And they are third-party neutrals that are appointed to literally apply the test of the best interest of the child. So typically you'll see either a child legal representative, a child and family investigator, or a PRE. Sometimes you might also see a guardian ad litem. All of those experts are really useful tools in getting information for the court, like what do the kids want given their age, or if there are issues of substance abuse, domestic violence, child abuse, they're sort of appointed to investigate those issues and make recommendations to the court. So a child and family investigator, or CFI, is a third-party neutral that's appointed by the court. In most of our cases, we see them in situations where there's allegations of substance abuse, domestic violence, child abuse, or if the parties just simply can't agree to a parenting plan that they think is in the child's best interest. So they will meet with both parties, meet with ancillary witnesses, and write a report explaining issues like how should decisions be made? What should the parenting time schedule be? And what is essentially in the child's best interest? What's really important to note about a child and family investigator or a CFI is that when we're looking to appoint those experts, they're not really there to advocate for the parents. They're more so there to advocate for what's in the best interest of that particular child or children if there's more than one child. The PRE, or the parental responsibilities evaluator, is very similar to a CFI in that they both sort of do an investigation. The difference between a PRE and a CFI is that a PRE is typically a mental health expert, and they can consider testing, like, let's say that one party is, saying the other party suffers from manic depression or schizophrenia or something that would impact their parenting. They're allowed to consider certain testing and statistical data that a CFI typically does not consider. In high-conflict family law cases, particularly where the parties are fighting over what's going to happen with the children, these types of experts can be very impactful because the CFI can meet directly with the child, and so can a PRE, and they can consider the statements of the child in making their determination as to what's in the child's best interest. Really, they're very important and very helpful in situations where we're trying to get through some issues that the court may not have time to consider. And that's why it's important to sit down with your attorney and identify what your goals are and identify what the challenges are. Because a PRE might not be necessary in a case where a child and family investigator might be better. And really, when I'm making that determination on my team, I typically try to identify what I think our obstacles are and what kind of training that particular expert needs. There's been a lot of changes in the case law recently that a CFI might be able to address that a PRE can't, and vice versa. And then when you're considering whether or not to appoint a CLR, typically if the children are older, that's a child legal advocate. That is very similar to a GAL, a guardian ad litem, and they are an attorney for the children. So if the child is older and they're really wanting to be heard, but we're not wanting to sort of have a report that someone can look at, I might call a CLR. Really, it just depends on what the needs of the case and what the obstacles are. Reach out to schedule a consultation and start your case with confidence.